All right, good afternoon, everyone, and welcome to the Maryland State Commission on Criminal Sentencing Policies, which we commonly refer to as the MSCCSP, our sentencing guidelines in MAGS 101, refresher training for state's attorneys, parole and probation investigators, and defense attorneys. My name is Catherine Pembroke. I'm the Administrative and Training Coordinator for the MSCCSP. I'm usually the first point of contact for the Commission, so if you've called or emailed with a guidelines or MAGS related question, I'm sure we've spoken at some point. Now, the sentencing guidelines play a significant role in supporting fair and proportional sentencing practice. And accordingly, your participation in this training, staying up to date on the sentencing guidelines, it is important because it helps to promote the consistent application of the guidelines. So I do want to note that today's webinar is being recorded and it will be uploaded to our training site. So let's talk a little bit about the agenda for today's training. As I mentioned, this training is going to be more of a refresher training. So it will cover much of the same material from past trainings. However, I've also incorporated some frequently asked questions as well as some new updates that I think you will find informative. So I'm going to begin by reviewing instructions and commonly asked questions that will cover a variety of topics to include sentencing guidelines eligibility, specific areas of guidelines calculation, and then we're going to wrap up with a demonstration in the Maryland Automated Guideline System, which we commonly refer to as MAGS. Now, this demonstration, it will include specific emphasis on new and important features that were deployed in MAGS 12.1 back in April, as well as some new features deployed in MAGS 13.0 at the end of August. Now, even though I've already compiled some questions for us to review, if I get to a topic that may be relevant to a question you have, please, we certainly encourage any and all questions to be submitted through our chat box. So my colleague Sarah Bowles is here with me today. She's happy to answer any questions that you have. I just ask that it be submitted through the chat box just because we have a lot of material we're going to cover and that will ensure that we get through the presentation in a timely manner. But that said, I'm happy to take any outstanding questions at the end of the webinar. Lastly, you should see a PDF of today's presentation coming through the chat box in a couple of minutes here, so you can feel free to download the PDF and save it to your computer for future reference. All right, so let's begin with a quick review. What is the purpose of sentencing guidelines? So the sentencing guidelines are a mechanism to encourage proportional sentences. The primary goal of the guidelines is to promote consistent, fair, and equitable sentencing practices, whereby offenders who are adjudicated of similar offenses with similar criminal histories, they're treated and sentenced alike. Now, the Maryland sentencing guidelines were designed to systematically account for the most common variations in offenders and their offenses. The sentencing guidelines help achieve proportional sentencing by identifying and assigning weights to core objective factors for consideration by judges in making sentencing decisions. Now, the guidelines account for the most common, but certainly not all, characteristics of an offender and their crime that are most relevant to the sentencing decision. And they really help to provide a framework to allow judges to consistently assign the same value or score as their colleagues around the state for each of these legitimate legal factors. Now let's talk a little bit about the guidelines worksheet itself. Now the guidelines worksheet serves two purposes. The first purpose of the worksheet is to inform the judge of the guidelines prior to sentencing. So Criminal Procedure Article 6-216, it indicates that the court shall consider the guidelines at sentencing. And in order to do so, a sentencing guidelines worksheet must be prepared. The second purpose of the worksheet is to provide data so the commission can make informed decisions about sentencing policy. Criminal Procedure Article 6-210 then requires the Commission to collect sentencing guidelines worksheets, automate the information, and monitor sentencing practice. And this is why it's especially important that we're getting as many guidelines worksheets submitted as possible so that we do have the data to make informed decisions about sentencing policy. So to get started, let's look at a common question regarding guidelines eligibility in general. Now, do Maryland sentencing guidelines apply to misdemeanors? The answer is yes. The sentencing guidelines apply to guidelines eligible misdemeanors and felonies that are prosecuted in a circuit court. Now, there's been some confusion in recent years. I've gotten more and more questions with many practitioners thinking that the sentencing guidelines apply solely to felonies that are prosecuted in a circuit court, and that's not correct. The sentencing guidelines apply to both guidelines eligible misdemeanors and felonies that are prosecuted in a circuit court. So let's take a look at the scope of the sentencing guidelines in greater detail here. So if we look to the left-hand side of this chart, these are sentencing matters that we refer to as guidelines eligible sentencings. So these require a sentencing guidelines worksheet. That's circuit court original sentencings, jury trial prayers and appeals from the district court, but only when a pre-sentence investigation is ordered. And when that is the case, parole and probation is responsible for initiating the guidelines worksheet. Also includes cases adjudicated via probation before judgments. And just to note, this also includes the new type of PBJ pursuant to Criminal Procedure Article 6-220C. Now, in addition to original sentencings, we also collect worksheets for reconsiderations, modifications, and three-judge panel reviews, provided that the sentencing event involves a crime of violence and that there was an adjustment made to the original active sentence as a result of the recent reconsideration, modification, or review. Now, on the right-hand side here, these are sentencing matters that you'll also see handled in the circuit court, but they are excluded from guidelines coverage. So this includes jury trial prayers and appeals with no PSI, offenses that carry no possibility of incarceration, violations of local laws and municipal ordinances, probation violation hearings, criminal non-support and criminal contempt, juvenile court adjudications, and then finally, the guidelines do not apply towards district court sentencings. So I do want to note that we have worked with JIS to identify guidelines eligible cases requiring a worksheet in all MDEC jurisdictions. So here's a screenshot of a circuit court docket that's run through Odyssey. And this is the criminal docket for the circuit court for Anne Arundel County. And you can see that the upcoming cases that are guidelines eligible are marked with this MAGS yes indicator. So I wanted to point out this tool to you if you think it would be helpful to reference these dockets, just so you can kind of keep track of which upcoming cases will require a guidelines worksheet so that you know to go into MAGS, initiate that worksheet prior to sentencing. So if you think this would be helpful for you to refer to, please do so. So here's another question regarding guidelines eligibility in general here. Now, let's say you're initiating a guidelines worksheet in MAGS and you're having trouble finding an offense in our offense table. And you're saying, why can't I locate this offense in the guidelines offense table? And the answer could be that it might not be a guidelines eligible offense. So let's take a look at two questions we get in particular. The first being a violation of Baltimore City Code 59-2, which is the discharging of a firearm. Now, even though this offense carries the possibility of incarceration, it's a violation of Baltimore City Code, and therefore it is not guidelines eligible. So if this particular offense is being sentenced with other guidelines eligible offenses, it would not be reflected on the guidelines worksheet or in our offense table because it's not technically a guidelines eligible offense. Another offense we get questions about is reckless driving. You often see it charged with other motor vehicle related offenses, but since it does not currently carry the possibility of incarceration, it would be excluded from the guidelines worksheet. However, I do want to note that effective October 1, 2025 this year, this offense will carry the possibility of incarceration and therefore become a guidelines eligible offense. So for any cases being sentenced on or after October 1, 2025, if it contains reckless driving, you will now be adding this offense to the guidelines worksheet. And I do want to note that just in general, new and revised offenses stemming from the 2025 legislative session will be added to our guidelines offense table on or about November 3rd. We're still going through the COMAR promulgation process before they can be officially adopted and added to our guidelines offense table. So you can expect those to be added on or about November 3rd. And as always, we will be sending out a guidelines e-news once these offenses are added to our table. Now, the last thing I want to note is that it is also possible that some of the more infrequent offenses that carry a maximum penalty of less than 1 year, they may not be included in our guidelines offense table, even though they're technically guidelines eligible. This generally happens when it's a rarer offense that's not often charged. And again, if it does carry the possibility of incarceration, but you're having trouble locating it in our guidelines offense table, please always feel free to call us. We can confirm whether or not it is in the offense table. And then if it's not, it would just be a rare scenario where it would require a manual calculation of the guidelines. All right, now just as a bit of a refresher, the Maryland guidelines are scored on two key factors, that being the prior record and the seriousness of the offense. So in the Maryland system, an offender score is calculated to account for an offender's prior criminal record. Now, the offender score is a summary scale ranging from 0 to 9, which measures an offender's criminal history, accounting for four factors. That being the relationship to the criminal justice system when the instant offense occurred, juvenile delinquency record, prior adult criminal record, and then finally any prior adult parole and or probation violations. The second component of the sentencing guidelines is the offense seriousness, which is represented in Maryland by the offense score. Now, for property and drug offenses, the offense ranking is based solely on the seriousness category of the underlying offense. But for person offenses, so those typically involving victims or weapon-related offenses, the offense score is calculated by considering three additional factors, that being victim injury, weapon presence, and special victim vulnerability. And we're going to get into each of these components in a little bit. But let's do a quick review of the four components that make up the offender score calculation. And let's start with a common question that we receive regarding the scoring of Part A of the offender score. Now, does pretrial supervision constitute criminal justice system involvement for the purposes of scoring Part A? That is the relationship to the criminal justice system when the instant offense occurred. And the answer is generally no. So let's take a look at why that is. Now, an offender should receive 1 point for being in the criminal justice system. For example, if they are currently on parole, probation, etc., as a result of an adjudication of guilt at the time the instant offense was committed. Now, criminal justice system involvement must be as a result of an adjudication of guilt. So, pretrial supervision or the defendant being out on bail would not normally count as criminal justice system involvement unless the defendant had been adjudicated guilty of an offense, was on pretrial supervision pending sentencing at the time the instant offense occurred. If that were the scenario, then that would constitute criminal justice system involvement. But generally, being on pretrial supervision would not constitute it because the defendant had not yet been adjudicated guilty for a particular offense. So here's another question pertaining to the scoring of Part A of the offender score. Now, does the sex offender registry constitute criminal justice system involvement for the purposes of scoring Part A? Again, the relationship to the criminal justice system when the instant offense occurred. And the answer is no. So at the Commission's September 17, 2019 business meeting, this topic was discussed and there was a majority vote against including sex offender registration in Part A's definition of criminal justice supervision involvement. Therefore, if the defendant was on the sex offender registry as a result of an adjudication of guilt at the time the instant offense occurred, as long as there is no other form of supervision taking place, meaning they're off probation, parole, etc., 1 point would not be scored for the defendant being solely on the sex offender registry. All right, so next we're going to move on to Part B of the offender score, that being juvenile delinquency. I'm going to quickly recap the criteria for scoring juvenile delinquency here. So 0 points are scored for juvenile delinquency if the defendant's 23 years old or older, or if they have zero findings of a delinquent act within 5 years of the date of the most recent instant offense. 1 point is scored here if the defendant's younger than 23 and has 1 to 2 delinquent findings within 5 years of the date of the most recent instant offense. 2 points if the defendant is 23 years younger than 23, excuse me, and has 3 or more delinquent findings within 5 years of the date of the most recent instant offense. So next we're moving on to Part C, the scoring of the prior adult criminal record. And we're going to spend some time breaking down the prior adult criminal record. We're going to look at some hypothetical sentencing scenarios because this is definitely the most complicated component of the offender score. Now, aside from a few exceptions that we're going to review in a moment, The prior adult criminal record generally includes all adjudications preceding the current sentencing event, whether the offense was committed before, during, or after the instant offense or offenses. And just something to keep in mind, if the defendant has been adjudicated in another case prior to this sentencing event, but not yet sentenced, you would still count that adjudication towards the prior record. It's based on the adjudication. All right, so here's an important question and answer to keep in mind regarding the scoring of the prior adult criminal record. Now, should adjudications that were expunged from the record or proven by the defense to have been eligible for expungement as a matter of right prior to the date of offense be excluded from the prior record score? And the answer is yes. So any adjudications that were expunged or proven by the defense to have been eligible for expungement prior to the date of the instant offense should be excluded from the prior record score. Now, a common instance of a prior adjudication becoming eligible for expungement, it may involve a prior probation before judgment. Maybe 3 years has lapsed since the defendant successfully completed probation in that case, so it would have been eligible for expungement. However, I do want to note that expungement laws have expanded over the years, and now certain prior convictions are eligible for expungement after a specific period of time. So Subtitle 1 of Title 10 of the Criminal Procedure Article outlines expungement criteria. So this is something to keep in mind. Now, as a reminder, the prior adult criminal record shall also exclude violations of public local laws, municipal ordinances, contempt, and criminal non-support cases, adjudications based on acts that are no longer crimes. So, for example, cannabis possession of 2.5 ounces or less is no longer a criminal offense. So if you are looking to the prior record, you see prior possession of cannabis. If you are able to determine that that involved 2.5 ounces or less, you would not score it towards the prior record. Non-incarcerable traffic offenses are excluded. And then finally, military adjudications imposed by an Article 15 proceeding or summary court-martial, as well as findings of guilt by general or special courts-martial, if the elements of the offense require the defendant's service in a military force, or do not constitute an offense under Maryland law. That would be excluded from the prior record. All right, so let's now break down the steps for calculating the prior adult criminal record. Now, the first step when reviewing a defendant's prior criminal history is to identify the offense with the highest seriousness category for each prior criminal transaction. So, for example, if you have multiple criminal adjudications stemming. Sorry, was that really echoey? Does that sound better, Sarah?
Yes, it sounds much better now.
Okay, sorry. So for example, if there are multiple criminal adjudications stemming from one criminal transaction, you identify the offense with the highest seriousness category for each prior criminal transaction. Step 2 would then be to count the number of offenses in each seriousness category using only those offenses that you identified in step 1. Then step 3 would then be to refer to our criminal record matrix to determine the prior record level. Now, before we walk through a hypothetical sentencing scenario, I do want to note that Maryland allows for what we refer to as the criminal record decay factor, meaning that if a defendant has remained free from criminal justice system involvement, meaning they have been off parole, probation, mandatory supervision for 10 years prior to this instant offense, the criminal record should be reduced by 1 level. So you would still calculate it as normal if it ended up returning a moderate record level. If the defendant's criminal history meets this criminal record decay factor criteria, it would be reduced from a moderate to a minor. So let's kind of put all of that together and look at a hypothetical scenario here. So let's say we have a defendant with the following prior criminal history. Let's say back in October of 2018, the defendant was convicted of a second-degree assault, which is a Category 5, as well as a resisting arrest, which is a Category 6. Now, since I have multiple adjudications stemming from this transaction, I'm only going to count the offense with the highest seriousness category, that being the second-degree assault, which is a 5. Then in 2022, we have a conviction for first-degree assault, which is a 3. And then finally, in 2022, a destruction of property less than 1,000, which is a Category 7. Now, between these three offenses that I'm counting towards the prior record, it's the first degree assault that has the highest seriousness category, that being 3. And I only have one seriousness category 3. So when looking to the matrix here, I'm going to look to my seriousness category column on the left-hand side here with the number of adjudications within that seriousness category as the top row here. So I have one seriousness category 3, which is the highest. So this is going to result in a moderate record level and then would jump to a major if combined with 2 or more offenses in categories 4 through 6 or any 6 offenses in general. Now, looking to these other offenses, I only have one other offense, that being the second degree assault, which is a 5 that falls within these categories of 5 through 6. So this would not meet the major criteria. It would remain a moderate. Okay, hopefully that helped walking through a hypothetical scenario, and we have another one coming up in a moment here. So let's look at another good question pertaining to the scoring of the prior adult criminal record. Now, if a seriousness category changes for an offense, which seriousness category do I use to calculate the prior adult criminal record? And the answer is the offense seriousness categories in effect at the time of sentencing shall be used to calculate the prior adult criminal record. Now, if it is determined that the guidelines are different than what they would have been if calculated using the sentencing guidelines and offense seriousness categories in effect on the date of the offense, the state or defense can bring that to the judge's attention at sentencing as a consideration for departure from the guidelines. So let's look at another hypothetical scenario here involving a criminal history where a seriousness category has changed for an offense. So in this example here, we have a possession of cocaine that occurred back in 2017. Then in 2019, there was a possession with intent to distribute cannabis. Now, possession with intent to distribute cannabis is now a seriousness category 5 due to the decreased penalty that went into effect on April 1 of 2023. So I'm using this new seriousness category when counting it towards the prior record. And then finally, in 2022, we have a conviction for possession of cannabis, but I was able to determine that it was 2.5 ounces or less, therefore no longer counted towards the prior record. So that's excluded. So now I'm just counting these two offenses towards the scoring of the prior record. Most serious is being the P of cannabis. So looking to the matrix here, I have one seriousness category 5 is my most serious offense, which means I'm looking at a minor record here and then would jump to a moderate if combined with not less than 3, nor more than 7, or a major if combined with any 8 offenses. So in this scenario here, it would remain a minor. So hopefully that was helpful to try to walk through a couple of different scenarios. Again, I know this is a complicated component of the offender score. If you ever have questions about scoring prior criminal history, you can always feel free to contact us. And then finally, wrapping up with Part D of the offender score, prior adult parole and probation violations. 1 point is scored if the offender was ever adjudicated in violation of parole or probation, or was adjudicated of an offense while on parole and probation, unless the adjudication arose from the offenses or offense of this sentencing event. All right, so next we're going to look to some questions and criteria pertaining to the offense score calculation. So again, this is involving person offenses. The offense score is only calculated for person offenses. And just as a recap, we're looking at seriousness category, victim injury, weapon presence, and special victim vulnerability. So let's jump into it here with Part A, that being the seriousness category. Now, looking at this conversion chart on the left-hand side here, we can see that X number of points are scored just based on the seriousness category of the underlying offense. So 1 point is scored for seriousness categories 5 through 7, all the way to 10 points for category 1. Now, in general, any attempt, conspiracy, or solicitation, it's going to be assigned the same seriousness category as the underlying offense. There's really one exception involving some of the more serious offenses. For example, attempted first-degree murder is a category 2, while first-degree murder is a category 1. The same is true of rape. So if you ever have a question about the seriousness category for one of those more serious offenses, when an attempt, conspiracy, etc. is involved, you can always refer to our offense table. We have those listed as separate entries. All right, so moving on to Part B, that being victim injury. So this is defined in our manual as reasonable proof of injury and may be physical or psychological, the cause of which is directly linked to the conduct of the defendant in the commission of the adjudicated offense. So non-permanent injuries are assigned 1 point, permanent injuries or death are assigned 2 points. Just to note, psychological injury shall be based on confirmed medical diagnosis or psychological counseling or treatment and is presumed not permanent unless otherwise demonstrated. Now, I do want to note that the Commission just recently voted to revise the instructions for scoring physical injury. These revisions, they need to go through the COMAR promulgation process before officially going into effect. So therefore, we do not anticipate the revisions to be formally adopted until early next year. But as always, we will be sending out a guidelines e-news notifying you when these changes go into effect. And before we move on, I just want to note just regarding victim injury in general, there does tend to be some gray area. It's just not possible for our manual to address and account for every single scenario involving victim injury. So ultimately, if our manual does not provide an explicit instruction, it's at your discretion as to whether you're scoring a non-permanent, permanent, injury, and if state defense, if they disagree, ultimately that can be brought before the judge at sentencing and the judge will make the decision. All right, so here's a question to keep in mind regarding the scoring of victim injury. Now, should non-permanent or permanent victim injury points be scored for offenses involving photographic or video evidence of child pornography? And the answer is that permanent victim injury points should be scored for these offenses. Now, this instruction can be found in our guidelines manual, and it is intended to apply permanent victim injury points to any offense involving photographic or video evidence of child pornography. And it is not limited to convictions for the possession, manufacture, or distribution of child pornography. It can be scored with any offense that does involve this photographic or video evidence of child pornography. So the scoring of permanent victim injury points, it recognizes that photographic and video evidence of child pornography often exists in perpetuity and that these victims of these crimes suffer lasting psychological consequences and are re-victimized every time an image is viewed, possessed, or distributed. Now, this instruction actually went into effect a couple years ago, but I like to highlight it in our trainings because just based on conversations I have with some practitioners, sometimes I'm reviewing a guidelines worksheet with someone and I see that it can involve a child pornography case and I don't see the permanent victim injury points. So I always like to highlight it, spread the word that in that type of scenario, 2 points, permanent victim injury should be scored. All right, moving on to Part C, that being weapon presence. Now, this is defined as the presence of any article or device that reasonably appears capable of causing injury. So 1 point is scored here for a weapon other than a firearm, such as a knife or a BB gun, 2 points for a firearm or an explosive. Now, I also want to note here that when calculating the offense score in general, the judge may include factors known to the judge outside of the scope of the convicted offense. So, for example, if a defendant is charged with armed robbery, pleads to robbery, points may still be awarded for firearm or weapon presence. Here's another question and answer to keep in mind relating to weapon presence. Now, how many weapon presence points are applied when a weapon is feigned? And the answer is 1. So this should be scored as a weapon other than a firearm. Now, a feigned weapon shall be scored 1 point when an individual intentionally creates the false impression that there is an actual weapon present, including a finger used to simulate a gun, a written note stating that there is a dangerous weapon present, or a verbal statement that there is a dangerous weapon present. In that type of scenario, 1 point should be scored for weapon presence. And then finally, wrapping up with special victim vulnerability. So 1 point is scored here if the victim is younger than 11 or 65 years old or older, or if they have a temporary or permanent physical or mental disability. And this includes an individual who's physically or mentally limited in a material way. So examples of a temporary physical or mental limitation include, but are not limited to, instances when the offender knew or should have known the victim was pregnant, unconscious, asleep, or intoxicated. So if any of these circumstances meet the case, the victim in the case, you would score 1 point for special victim vulnerability. Now let's talk a little bit about the overall guidelines range calculation in general here. And this is a common question that I receive. So if the indictment includes multiple offenses that were committed over a period of time, should they be treated as one criminal event or multiple criminal events? And the answer is that it really just depends on the circumstances of the case. So I often get this question when it can involve, child sex abuse that occurred over a period of time with multiple distinct sex offenses kind of within that range. Should that be treated as one ongoing criminal event or multiple criminal events? And again, it just depends on the circumstances of the case. But to maybe help provide some guidance, let's review the definitions of what constitutes a single criminal event versus multiple criminal events for guidelines calculation purposes. So a single criminal event is defined as one or more crimes committed in the course of the same transaction. Now, in determining whether multiple crimes are committed in the course of the same transaction, the person filling out the guidelines worksheet shall consider whether the crimes are one, committed close in time in an uninterrupted course of conduct, two, occur in the same location, and three, are similar in nature or intertwined. So, for example, whether they share a common scheme or purpose. Whereas multiple criminal events means that more than one criminal transaction was committed over a period of time. Now, multiple criminal events being sentenced together, they may have occurred on the same date or different dates, but generally offenses that occur on different dates are almost always considered separate criminal events. Now, taking that together, let's quickly review what constitutes a sentencing event. So this is going to be really important to keep in mind when we get to our MAGS demonstration. Now, a sentencing event is defined as a sentencing disposition or hearing for an individual defendant conducted in front of one judge on the same day. So when you have multiple criminal events, right, which often have different offense dates, different case numbers, if they are being sentenced by the same judge on the same day, they constitute one sentencing event, meaning that one set of sentencing guidelines should be completed for each sentencing event. And we'll talk about this again when we get to the MAGS demonstration, but also just want to note that merged or null pros offenses should not be included in the guidelines worksheet. So if you initiate a guidelines worksheet only to have some offenses be merged or null pros, you want to make sure you're removing them from those offenses from the guidelines worksheet. Now let's look at a common example of a special application that adjusts the overall guidelines range. And this is what we refer to as our guideline stacking rule. Now, here's an example where the overall range is adjusted due to a case involving multiple victims within a criminal event. In this type of case, the guidelines range for each individual offense is still calculated as normal, but instead of using the highest of the upper and lower guidelines limits, it's the highest of the lower limits that's taken, and the upper limits for each offense involving a unique victim are instead added or stacked. So in this particular example here, let's say we have an individual who is convicted of 3 counts of assault second degree, each involving a unique victim. So I can see the stacking rule was applied to each offense. Victim number 1, 2, and 3. So each distinct victim here. So the individual guidelines range is calculated for each offense. But again, the upper limits for each offense involving a unique victim are instead added or stacked to give you a greater overall guidelines range of 2 years to 15 years to reflect the multiple victims involved in the criminal event. So let's quickly recap the criteria for utilizing the stacking rule. Now, in order for the stacking rule to be utilized, there must be a criminal event with multiple distinct victims. There cannot be more than one seriousness category 1 or 2 offense, and only one adjudicated offense per distinct victim may be used to calculate the overall guidelines. So if you have multiple offenses that relate to the same victim, you're only stacking the offense with the highest seriousness category. And then finally, it's only the upper limits that stack. So let's look at a couple of questions related to the stacking rule here. Now, is the victim stacking rule limited to person offenses? And the answer is no. So it is not limited to person offenses. You could certainly utilize the multiple victim stacking rule for property offenses as well. So for example, if you had maybe a theft scheme that involved multiple unique victims, you could certainly utilize the multiple victim stacking rule in that type of scenario as well. And then another question, are animals considered victims for the purposes of applying the stacking rule? So this is a bit of an update here. Effective October 1, 2025, the answer is yes. So pursuant to Senate Bill 152, House Bill 89, which was passed this legislative session, each animal harmed in violation of Section 10, Subtitle 6 of the Criminal Law article shall be considered a victim when applying the stacking rule. So to note, this wouldn't apply towards hunting or fishing offenses, but instead generally applying in multiple animal cruelty cases or cases with multiple counts of animal cruelty. So I do want to note, again, this will be an update coming forward on October 1 because currently we do have language in our manual that explicitly excludes animals from the multiple victim stacking rule. But again, pursuant to this legislation that was passed this year, animals will be considered victims for the purposes of the stacking rule, as long as they are applicable. Okay, so that kind of wraps up the refresher part of the training. I'm going to move into the MAGS demonstration. I'm seeing some questions coming through in the chat. Is there anything we want to review about any of the topics I just discussed before I jump into MAGS? Give everyone an opportunity. Okay. Again, we'll have some time to address any outstanding questions at the end of the MAGS portion. So let's just go ahead and keep it moving. If you can give me 1 second, I'm going to go ahead and pull up MAGS. So just bear with me here. Okay, so you should actually be seeing our main, this real quick, our main homepage here. Before I log into MAGS, I do want to quickly point out our guidelines calculator tool. For any defense attorneys who may be attending, as well as parole and probation in the state's attorney's office. I know many practitioners who like to utilize our guidelines calculator tool. So quickly to recap, the guidelines calculator tool, it's a standalone tool that can be utilized by anyone to calculate sample guidelines. You don't need a user ID, you don't need a password, and it essentially mirrors MAGS. So what I'm about to show you in MAGS applies to the guidelines calculator tool as well. So again, any defense attorneys who may be attending this training, please, I encourage you to stick around so that you'll know how to utilize the guidelines calculator tool if you wish. For state's attorneys, I know some of you like to utilize the guidelines calculator tool, maybe just during like plea negotiations when calculating some sample guidelines. But just a reminder to ultimately make sure that you are initiating the official guidelines worksheet in MAGS when the time comes. So I'm going to go ahead and log into MAGS at this point in time here. Okay. So after logging into MAGS, you're brought to the home screen here. It's from the home screen where users can either create a new worksheet or view, edit, or delete an existing one. Now, I am going to be walking you through how to correctly initiate a multiple criminal event, single sentencing event scenario. But before I do that, I want to point out a couple of relatively new features that we have in MAGS. The first being this reconsideration modification or three-judge review for COV sentences feature. Now, I talked earlier in the presentation about how, in addition to original sentencings, we collect worksheets for reconsiderations, modifications, and three-judge panel reviews, provided that the sentencing event involves a crime of violence and there's an adjustment made to the original active sentence. Now, prior to MAGS 12.0 that was released last year, state's attorneys were having to essentially initiate worksheets for those upcoming reconsiderations, modifications from scratch. And just to note that the guidelines in that type of scenario should match the original guidelines calculation. So this feature that we've implemented here, it really streamlines the worksheet initiation process for you all when you are trying to initiate a worksheet for an upcoming reconsideration, modification, or review. Because now it essentially allows you to copy the original guidelines calculation as long as the worksheet for the original sentencing was submitted in MAGS. So let me show you quickly how this works. So let's say you have an upcoming reconsideration involving a crime of violence. So you're going to go ahead and check this little box here. You can see once I do that, many of the search fields become disabled, grayed out, and you can only search by case number. So I'm going to go ahead and just search for this case number. and click search here. So you can see once I do that, I get a return for a John Smith. I see a sentencing date of 11/03/2023. And if I look under the submitted box here, I can see that it was submitted. There's a little check mark. And then looking to the left here, again, MAGS is confirming that it was submitted. And then it gives me the option. This little copy icon will give me the option to copy that worksheet for the upcoming reconsideration, modification, or review. So I'm going to go ahead and confirm that I want to copy it, which is going to bring me to the offender information tab. So if I scroll down further, you will see that much of this information pre-populates based on the information that was submitted on the original worksheet. Most of it is also disabled, so you can't make edits to it. But with that said, there are a couple of fields where responses could have changed or be different for the reconsideration, modification, or review. So you could still make edits as applicable. So really, in this type of scenario, if you're copying the original worksheet, generally, you would just be putting your worksheet preparer name with your title or agency here, and then clicking Save this page. Now, it's possible that the original worksheet was submitted without an ethnicity or race field. Those only became mandatory fields a couple of years ago. So if it's a really older worksheet, it's possible those fields may be missing. And because they're mandatory, it's going to prompt you to make a selection there. But again, in most cases, you should just be able to enter the worksheet preparer name and title or agency. And then if I were to quickly scroll through offender score, again, pre-populates, has all of the original offense information. I can't make edits to it. And then you would simply just proceed with entering any victim information that pertains to the current reconsideration, modification, or review. So that's it. That's how the feature works. I wanted to point that out to you in case you weren't aware of it, and that will save you a lot of time in the future. Okay, so jumping back to the home screen here. Now, prior to initiating a worksheet, you always want to search the system to make sure you're not duplicating an already initiated worksheet. So this is especially true with state's attorneys and parole and probation. It's possible in some cases the state's attorney initiates the guidelines worksheet not knowing a pre-sentence investigation is going to be ordered. So in that scenario, parole and probation should come in, search the system. If they see that the state did initiate a worksheet, they can view the calculation. If they agree with it, it really can be kind of left as is. However, if there's a review of the guidelines calculation, maybe you have additional information or don't agree with a particular calculation, then we ask that both parties have a conversation in hopes of reaching a consensus and then making edits to the one initiated worksheet in the system. Again, we want to avoid duplicating worksheets. Otherwise, it gets very confusing for judges and their designees to know which worksheet to ultimately submit post-sentencing. Now, for any defense attorneys who may be on this training, I do want to note that you all have read-only access to worksheets in MAGS. So again, while you do not have editing capabilities, we certainly encourage you to log into MAGS, view the guidelines calculation, and you can certainly utilize the guidelines calculator tool to calculate your own sample guidelines. If there's a discrepancy between calculation, that can be brought to the judge's attention at sentencing. Okay, so here I'm going to go ahead and just quickly search for a case that I previously initiated here. So I'm going to filter first by Hartford and I'm going to search for a Thomas Adams. Okay, so once I do that, you can see I get a return for two case numbers ending in 1144 and ending in 1157. Now, if I look to this left-hand side where I see the worksheet ID column here, I'm going to sound like a broken record by the time this training's over, but when you have multiple criminal events that are sentenced in front of the same judge on the same day, you want to make sure you're initiating them under one worksheet ID in MAGS. That is to ensure that the judge is presented with a proper overall guidelines range prior to sentencing, and also to ensure that the judge or judge's designee does not run into an issue when they go to submit the worksheets. So in this case, let's say these two cases are being sentenced as part of the same sentencing event. But if you happen to click the Add New button 2 times here, thus creating a separate worksheet for each case number, that means that they would have different worksheet ID numbers. And again, the first and most important issue there is that the judge has not presented a proper overall guidelines range, if that's the case. The second is that the judge or judge's designee, they'd be able to enter sentence information and submit the first worksheet, but they're going to get a duplicate error message when they go to submit the second worksheet. And it's going to say, there's already been a worksheet containing the same SID number, date of birth, and date of sentence. And then they have to contact us. We combine it for them and send them back a revised PDF. So all that to say, you want to make sure you are properly initiating a multiple criminal event, single sentencing event scenario correctly. And in fact, we implemented a new feature in MAGS back in April to hopefully prompt you all to properly initiate the multiple criminal event, single sentencing event scenarios. So let me show you how it works. Let's say in this scenario here, we already know this Thomas Adams has two cases being sentenced together. Maybe I didn't search the system ahead of time. Maybe I'm not even thinking that this case I'm trying to initiate may end up being sentenced with these two case numbers. So I'm just going to go ahead and click Add New from scratch here and confirm that I want to initiate a new worksheet. So then I just start by entering my information here, as well as the last name, first name of the defendant, and the SID number, the sex, the date of birth, and let's say this is Hartford, public defender, no ethnicity. And then just to note that race does allow for multiracial responses, so you can select more than one here. And then I'm clicking Save This Page. Okay, if I am initiating a worksheet that matches information for another existing worksheet ID, I'm going to get this duplicate worksheet message. And I know it's a lot of text, but it's important. So bear with me while I read through it real quick. So this says the offender's name, date of birth, and jurisdiction are the same as another existing worksheet ID. If there are multiple cases being sentenced as part of the same sentencing event, again, on the same day, same judge, the worksheets for all cases need to be initiated under one worksheet ID to ensure proper calculation of the guidelines. So if you are attempting to enter information for a case that is being sentenced on the same day and in front of the same judge as one of these existing cases below, please click Select next to the case information of the already existing worksheet and then add this instant case information. Now, if I were initiating this worksheet, even though it matches some information for the existing worksheet IDs I see here, if I know for a fact that the case I'm initiating is being sentenced separately on a different day, maybe a different judge than these two case numbers, you can just click Continue with Initiating Worksheet ID for new sentencing event, and MAGS will let you continue on your way. However, once you get this alert, if you look at it and you're like, oh, wait a second, my case is going to be sentenced with these other case numbers, that means you want to select one of the worksheet IDs here. Now, in this scenario, this is a little bit easier because I already have these two case numbers under the same worksheet ID. So it doesn't matter which one I click, it's still going to bring me to the same worksheet ID. However, if there were already multiple case numbers initiated separately in the system, so you had different worksheet IDs, ultimately you have to combine all of the case numbers under one worksheet ID. So just pick one worksheet ID and then make sure you add all of that unique case number information to that worksheet ID. So here, again, doesn't matter because they both have the same worksheet ID. I'm going to click Select. Then I'm going to get an alert. It's telling me, okay, now you're editing that worksheet ID that you just clicked on, and you click OK. So really, in this case, at this point, most of the offender information, offender score, list of offenses has probably already been saved for that existing worksheet ID. So you should just be able to jump to list of offenses here, where you see those other unique case numbers listed. And then, so you can see I have event number 1 for the 1144, event number 2 for the 1157, and then you would simply click Add Offense to bring you to the offense offender score screen. And let's say for my case number that I was going to initiate, it occurred on a different day than those other two cases. It has a different case number. So then I would treat this as criminal event number 3, and then continue on. I'm not going to go through completing this entire screen because I'm going to show you how to do a multiple criminal event from scratch, but that's how you would want to utilize that duplicate worksheet feature if you do get it when you initiate a worksheet. And again, the goal here is just to make sure that the guidelines are properly calculated prior to sentencing. So that was an exciting feature, and we were happy to deploy it. So if you ever have questions about it, you can feel free to contact me as well. Okay, so now we're back to scratch, the beginning. We're going to quickly walk through initiating a multiple criminal events, single sentencing event scenario. So I search the system. I don't see a duplicate. I'm going to go ahead and again, click add new. Okay. All right, we've been here a couple times at this point, so I'm going to quickly scroll and enter some information for my defendant here. Let's do two. So no PSI. Let's say this is Kent County. We'll say private representation and then select two responses here, saving this page. Okay, now jumping forward to the offender score. So again, we already reviewed the components that make up the offender score. Just to note, Part A, relationship to the criminal justice system when the incident offense occurred, that is scored at the offense level, because it's possible that score could differ if you have multiple offenses in a sentencing event that occurred on different times. So you would then just begin by scoring juvenile delinquency, prior adult criminal record. So again, just to note, if you're applying the decay factor, you would score at the initial prior record level and then click yes next to apply decay factor. You can see once I do that, it jumped down from a major to a moderate. And then when you view the worksheet, it actually will say decay factor in red text. So it's clear that that was utilized. And then prior adult parole and probation violations. Also, quickly to note, throughout MAGS, you'll see these information icons. If you click on them, they give you more detailed explanations of what you're trying to capture. So if you ever have a question, utilize the icons. They're extremely helpful. All right, saving this page. And now moving on to list of offenses. So again, multiple criminal events, single sentencing event scenario. This is the tab where you're going to add all of that unique case number information. So, and you're going to begin by clicking add offense, which brings you to the offense offender score screen here. So you want to be, when you do have multiple criminal events, single sentencing event scenario, it is very important that you're making sure that you're properly noting the event number that is associated with each offense. Because if you do have multiple criminal events, you want to make sure you're putting event number 1, event number 2, etc., so that MAGS knows to add those ranges together. That's how it knows to adjust for the overall guidelines range. So that's important. So let's start with event number 1, and then you want to put the count number that corresponds to the offense as it's noted in the indictment. And then I'm just going to begin with my, whoops, no, that's right. Offense date and my case number. Now, another new feature here that was deployed at the end of August with MAGS 13.0 are these new buttons for the most common offenses and search for all offenses button. It now makes those two options more distinguishable. So if you want to search for our most common 25 most common guidelines eligible offenses, you just simply click this button and you can scroll. Or you can search our entire offense table by clicking search for all offenses. And then you can further filter by offense title, CGIS code, source code, or type. Now, just something to keep in mind regarding the source code, that being the statute, is that with some of our offense entries, we contain penalty portions of statutes. So if you're searching for the offense portion of the statute, like very specifically, it may not be a direct match is what I'm getting at. So if you have trouble locating an offense that you're searching by the statute, it's best to search generally. For example, for like a drug related offense, if you just want to do like 5-608 instead of putting in all the subsections, this will bring you back a return. And also always good to search by CGIS code if you have a specific CGIS code. Now you can simultaneously search all of these columns by utilizing the search button in the upper left-hand corner here. So for example, if I were just to type in assault, all of the offenses containing the word assault populate here. And I'm looking for assault first degree, so I'm going to select. Once I do that, MAGS populates seriousness category, CGIS code statute, stat max, and if there were a mandatory minimum here. If you're applying an attempt, conspiracy, or solicitation, again, generally you're selecting the underlying offense and then clicking the appropriate radio button, with the exception for those more serious offenses that I talked about earlier. So for example, if I go back and type in murder, I can see I have a separate offense entry for attempt, conspiracy, etc. And then if I were just to select murder first degree and I'm trying to do an attempt, it's going to be grayed out because it's prompting you to go back and select that offense entry. So let me go back to my assault here. Okay. Any additional enhancements, for example, if the defendant's being convicted as a subsequent drug offender under criminal law 5-905, you could apply that enhancement here. Being convicted of a subsequent crime of violence and therefore subject to a 10, 25-year or life mandatory minimum, or if the defendant's a repeat sex offender and subject to the life max in 3-313, you would apply those enhancements here. Now, in this scenario, I do want to apply the multiple victim stacking rule. So I am going to do a criminal event that involves two distinct victims. So I want to begin by flagging this offense, and it's going to remind you of the criteria here. You click OK, and then you're going to be prompted to select the victim number that corresponds to the stacking rule here. So this is going to be victim number 1. Jumping down, I would then make my selection under the offender score here for Part A, relationship to CAJS when the incident offense occurred. Everything else pre-populates based on what I've previously selected. Then I jump over to the offense score. This is a person offense, assault first degree. MAGS automatically calculates the seriousness category for me, and then I just make selections for victim injury, weapon presence, and special victim vulnerability. And then I click calculate guidelines range. And then I get the individual guidelines range for the case, overall for the sentencing event, saving this page and close. Okay, I know we only have a couple minutes left, so I'm running through this. Here we go. Okay, so now I have my assault first degree. With my case number here, I'm going to go ahead and add a second offense to that same criminal event number. So it's going to be, again, event number 1, but this is going to be count 3 within that event number. It's going to have the same offense date that I just entered, as well as the same case number. These occurred at the same time. They're a part of the same criminal event. This is going to be a second count of assault first degree, but it involved a second victim. So I'm utilizing the stacking rule here and making sure that this is flagging victim number 2. And then again, jumping down, part A will be 0, and then let's say there was no injury here. There was still a weapon other than a firearm. In this case, there was special victim vulnerability. So now I'm clicking calculate guidelines range, save, and close. Okay, so now just looking at the overall range, I can see it's correctly stacking the upper limit since I utilized the stacking rule. So I'm seeing an overall of 6 to 24 right now. All right, so now I'm going to quickly add 2 offenses pertaining to a criminal event number 2. So this occurred on a different date, different case number. It's just being sentenced at the same time. So this is going to be criminal event number 2, count 1. So this occurred about a month later on March 15th, and it's going to have a different case number. Now here, I'm looking for a distribution of heroin. So I'm just going to type in heroin distribution. Not applying any special enhancement here. Jumping down to offender score, this is going to be 0 for part A. Now this is a drug-related offense, so I'm not prompted to complete the offense score. And I quickly go down to calculate guidelines range, save this page, and close. All right, adding one more offense to criminal event number 2. So this is still criminal event number 2. This is count 5. So it has the same offense date as what I just entered and the same case number, the 3344. Now I'm going to search by this term knowingly. So I'm searching for this offense here, the knowingly violating criminal law 5-602 with a mixture of heroin and fentanyl. I'm clicking select. So this is a drug offense. I'm not applying any sort of enhancement, scoring 0 for part A, and just simply going down to calculate guidelines range. You can see when I do that, I get this little alert. It's saying mandatory consecutive offense. Please select an offense for this to run consecutive to. Now I'm going to click on this information icon here. Now, to obtain the upper limit of the overall guidelines range for a criminal event with multiple offenses, when you have a sentence for one of the offenses that is statutorily required to run consecutive to the sentence for another offense in the same criminal event, the person completing the sentencing guidelines worksheet shall add the upper limits of the guidelines ranges for the 2 eligible offenses whose sentences are required to run consecutive to one another. Now, statutorily, the sentence for this offense And actually, one more update that came through with MAGS 13.0. If you put your cursor in the offense title and then just use your little arrows, you can scroll through the whole offense, which is kind of cool. Okay, so statutorily, the sentence for this offense is to run consecutive to any other offense in this criminal event. So this is why MAGS is prompting you to link this offense to another offense in the same criminal event so that it can add the upper limits together to reflect that consecutive nature. Now, let's say maybe you missed it or you weren't really sure what was going on with this and you clicked save this page and close. I want to show you how MAGS kind of alerts you again, saying you need to address the offenses that have warnings. And I can see if I were to scroll here, I see a little alert message next to count 5 here. If I click on it, it's going to tell you the mandatory consecutive offense is missing. Would you like to select one? You click OK. Oops. Okay. Which brings you back to the offense offender score screen. So again, this is prompting me to link this offense to another offense in the criminal event. In this case, I only have one other offense, that being the distribution of heroin. So I'm going to select that here and jump down and click save this page and close. And now I get the proper overall guidelines range of 6.5 to 32 years. So it's essentially stacking all of these upper limits per the various rules, the stacking rule, the mandatory consecutive sentence rule, etc. Now, just to note, this mandatory consecutive offense feature, you're only going to see that if there's about 10 offenses that we identified around that number. So it's not super common, but I want to show you how you would utilize that feature if it were to appear. Okay, so now I have all of my offenses here. We're jumping to our last and final tab, which is the victim information. I mentioned this earlier. This is where we collect information pertaining to the rights of victim at sentencing. So we do ask that you complete as many fields as possible prior to sentencing. That said, there are some fields that cannot be completed until after sentencing. For example, whether the victim was present, if they gave a written or oral victim impact statement. So the judge or judge's designee would be responsible for completing those fields post-sentencing. All right, so at this point in time, I've completed my multiple criminal events, single sentencing event scenario. So I want to view my worksheet here. I'm going to click View Worksheet PDF. And I can see here I have my completely initiated worksheet. Now, just to note as well, when you have multiple criminal events, as long as you correctly initiated them here in MAGS, by guidelines rule, each separate criminal event should correspond to their own worksheet, which is why in this PDF here, it contains 2 worksheets. The first one's for the criminal event that ends in 1122. I can clearly see my stacking rule utilized. And then if I were to jump down, I see criminal event number 2 for the case number ending in 3344. Already had that consecutive sentence field flagged on here. And then again, one overall guidelines range calculated between them. Okay, so that is how you properly initiate a multiple criminal event, single sentencing event scenario. Before I just wrap up with our contact info and some resources, does anyone have any questions in MAGS while I'm still in the system, or about MAGS rather? Okay, I'm not seeing anything. Just one last thing to note, I talked about merged or null pros offenses. So really quick, if you have a sentencing and offense did end up being merged or null pros, you would simply come back to this list of offenses tab and just click the trash can icon next to the offense that ended up being merged or null pros, and then MAGS would recalculate the overall guidelines for you. Okay, so bear with me. I'm just going to pull up the last slide here, and then we will conclude for the day. Okay, so just wrapping up with a couple of our resources. Our main website has a ton of material, helpful resources for you. It contains our annual reports, prior guidelines e-news. We have reports on guidelines compliance and average sentences for common offenses, our sentencing snapshots. We also have access to MAGS and our guidelines calculator tool, various instructional videos, as well as our crimes a violence data dashboard. We also have a data download tool available if you're interested in taking a look at our data. You can certainly download that via our main website as well. So at this point in time, that concludes this training. I know we went a couple of minutes over, but I appreciate you all hanging on. You can always feel free to contact us 301-403-4165 or via email at msccsp@umd.edu. I'll give, are there any outstanding questions before we hop off? Sarah, I'll check in with you too. Anything we want to bring up before we conclude?
No, we're good here.
Okay. Anyone else have questions? I'm not seeing anything. Okay, great. All right. Well, thank you all again for taking time out of your day to attend this training. I know we covered a lot of material, may have been a little overwhelming. I know I went fast at times, but I hope you found it to be helpful and informative. And with that, I hope you have a great rest of your Friday and a great weekend. Take care, all.